When it comes to trusts, there are 3 roles that must be filled in order for a trust to be created. There must be a grantor, a trustee, and a beneficiary. Now, these are long-term roles, but sometimes in the administration of a trust, we need someone to step in to carry out certain enumerated administrative or strategic purposes of the trust that are not reserved to the trustee, grantor, or beneficiary. This is where a trust protector comes into play. Hi, I'm Antoinette Bone, estate planning, probate, and guardianship attorney in the Dallas-Fort Worth metroplex. And today I'm going to discuss what is a trust protector, the advantages of appointing a trust protector, and the importance of picking the right person. A trust protector is a designated third party who holds one or more powers capable of affecting what the trustee is able to do with the trust property. It's important to note that a trust protector is not a trustee, nor do they have a beneficial interest in a trust. A trust protector is to a trustee what a corporate board of directors is to a CEO. A trustee manages the trust on a day-to-day basis. The trust protector has certain powers over the trust and weighs in on specific critical decisions as identified in the trust instrument. So why designate a trust protector? Well, trust protectors give the trust an added layer of flexibility to allow the trust to grow or change over time. And why is this important? Because once a trust becomes irrevocable, for example, after death, changes can no longer be made to the trust itself. If trust laws change, a beneficiary's circumstances change, or there is a defect in the trust, a trust protector would be able to make the requisite changes. Without a trust protector, a court would need to get involved in order to correct defects or make the trust compliant with current law. A trust protector can also be granted certain trust powers to avoid conflict between trustee and beneficiaries. For example, if the trustee is a surviving spouse and the beneficiaries are stepchildren, a grantor may wish to place certain trust powers in the protector to avoid placing unnecessary pressure on a relationship that may already be tenuous. These powers could be making investment decisions, distribution decisions, and conflict resolution. The stepfather trustee could rely upon the trust protector to mediate conflicts or avoid disputes. A trust protector with the power to remove and replace the trustee can do so if the trustee develops a conflict of interest or fails to manage the trust assets in the beneficiary's best interests. A trust protector with the power to modify the trust terms can correct mistakes in the trust document or clarify ambiguous language. Or a protector with the power to change the way trust assets are distributed if necessary to achieve your original objectives can help ensure your loved ones are provided for in the way you would have desired. Now suppose, for example, that your trust provides that assets will be distributed to your son after he graduates from college and is gainfully employed. But after college, your son decides to spend 2 years in the Peace Corps. If that doesn't meet the trust strict definition of gainfully employed, yet your son did well academically and has demonstrated an ability to manage money responsibly, the trust could authorize the trust protector to modify the trust to allow for early distributions. There may be inadvertent tax consequences if a trustee holds certain powers, which can be avoided by placing those powers in a trust protector. A trust protector can also protect assets from being drained to pay beneficiary creditors. For example, if a beneficiary serving as trustee becomes insolvent and the trust assets could become vulnerable to the beneficiary's creditors, a trust could grant the power to the trust protector to terminate the beneficiary trustee's ability to distribute assets or to remove the beneficiary altogether for a set period of time. Another benefit to appointing a trust protector is for privacy reasons. To avoid private information being made public in a court proceeding, a trust protector can be granted certain powers that would make a court proceeding unnecessary. These powers include arbitration, determining a beneficiary's incapacity, construing the trust agreement, and directing administrative administration modifications. And finally, granting the trust protector the following powers would prevent trust assets from being drained: arbitrate disputes, modify agreements to correct defects or take advantage of new tax laws that are favorable to the trust, make changes to investment or self-dealing provisions, add or remove beneficiaries, and terminate the trust. If a trust protector is not appointed to make any of the above named changes, it would require court intervention, which is costly and time-consuming. Choosing the right trust protector is critical. Given the power he or she has over your family's wealth, you'll want to choose someone whom you trust and who's qualified to make investment and other financial decisions. A grantor ideally wants to appoint someone they trust to act to protect the trust property and execute the trust purpose in the same manner as the grantor. The protector should not be someone related to the grantor, nor should the protector be a named beneficiary. The protector should be a disinterested third party in order to avoid a conflict that would prevent the protector from fulfilling their role. In sum, it's important to name a trust protector to preserve trust assets from being drained by litigation and protect private information from becoming public in the event changes are needed to be made to the trust due to defects or changes to the laws, to prevent inadvertent tax consequences to the trustee, and to mitigate potential conflicts between trustee and beneficiaries. Appointing a family member as protector is possible, but it can be risky. If the protector is a beneficiary or has the power to direct the trust assets to him or herself, or for his or her benefit, this power could be treated as a general power of appointment, exposing the protector to gift and estate tax liability and potentially triggering other negative tax consequences. I'm Antoinette Bone, estate planning, probate, and guardianship attorney in the Dallas-Fort Worth metroplex. If you found this content useful and would like to see more like it, please subscribe to my page, like this video, and don't forget to tell your family and friends. Thanks for watching, and I'll see you next time.